Good afternoon, everyone. I think we've just started. I can see that the participants number is filling up. So we'll just wait just one moment as I think people join us in the call. Slightly stabilizing now. Well, actually, no, it isn't. Well, welcome everyone anyway. I think a few more people may be coming in as we go, but for now, we can get started. And welcome to this webinar on the Equality Act and immigration. I'm very pleased today to be joined by brilliant colleagues. First of all, Simon Cox, who's just joining us from a relaxing day in the Court of Appeal, and consequently making me feel quite underdressed. Simon is a specialist in judicial review, immigration, EU and international law, social welfare and discrimination law. And secondly, we're joined by Catherine Meredith, a leading human rights and anti-trafficking practitioner, specialising in public law, anti-discrimination, asylum and immigration, immigration detention, and women and children's rights. This webinar forms part of a wider series that is going on in Chambers named 15 Years of the Equality Act. We're looking at the past, present and future of that bit of legislation. And there'll be barristers from across different practice teams that will be looking at the Equality Act from different angles. And it's leading up to an in-person event later on in the year. So do keep your eyes peeled for that and all those other webinars as well. And next slide, please. In terms of a structure of today's webinar, we're going to be focusing on the interaction between the Equality Act and immigration law. We're not intending to do a sort of exhaustive case recap, but to do a little bit more of a think about whether the Equality Act is capable at the design level of achieving its aims, whether over the 15 years of its existence it has achieved those aims, and if it hasn't, then the extent to which we can reimagine how it might. The structure is going to be as follows. I'm going to briefly take us through just the statutory framing of the Equality Act, and in particular the statutory exclusions that relate to immigration law in particular. I'll then discuss how that statutory framing gives rise to effectively an inbuilt acceptance of discrimination or an inherent acceptance of discrimination in the immigration context, and how that plays out in individual immigration decision making as well as in the rules, the headline being that the design of the Equality Act has meant that in that area it hasn't had as much of an impact as perhaps might be hoped, but there is some scope for discrimination related arguments, particularly using ECHR based principles. Secondly, we're going to hear from Catherine, who's going to discuss the extent to which the Equality Act affects or has affected immigration detention and the value of raising those Equality Act arguments in that context. Thirdly, we're going to hear from Simon, who's going to set out his thoughts on the interaction between the Act and asylum support and accommodation and how that's changed over time. And then finally, we'll have some time for questions at the end of the session. The plan is to take them at the end rather than as we go. But please do feel free at any stage in the seminar to ping questions in the chat, and in the Q&A box, we'll pick them up towards the end. And next slide, please. So just briefly, just to frame our discussion in terms of the statutory framework, a lot of this will be well familiar, but just to set out some of the central principles of the Act. Next slide, please. As is well known, Schedule 3 of the Equality Act excludes key immigration-related functions from the scope of Section 29 of the Equality Act, which is the aspect of the Equality Act dealing with service provision. This wasn't unique to the Equality Act. Prior bits of equality legislation also had similar exemptions. So I suppose you could see this not as all being the Equality Act's fault so much as a missed opportunity at the Equality Act stage to narrow perhaps some of these exemptions that we're going to see, which are fairly broad, although there are some interesting, perhaps interesting omissions that I'll discuss very briefly. Schedule 3, para 2, subparagraph 3 provides that the making or approving or considering instruments made by ministers are not covered by the Equality Act. So that includes the immigration rules. Part 4 of Schedule 3 then deals with specifically immigration functions, and there are slightly different rules for the different protected characteristics, something that I certainly wasn't familiar with in great detail before coming to this. And there are some interesting nuances here. In essence, government officials performing functions under the Immigration Act and related legislation are exempt from discrimination legislation on the grounds of age. Then there's also exemption on the grounds of nationality and ethnicity, which is a narrower definition than race itself, which is defined in Section 9 of the Equality Act. It's not clear what room that leaves. So there's nationality and ethnic origins. That leaves colour as a form of discrimination that an immigration official is capable of engaging in. There's a case called Tamil Information Centre and Secretary of State in the admin court, which is under the previous Race Relations Act regime, where in essence the Home Secretary sought to provide an exemption to or an authorization to its officials to treat passengers or people seeking to come to the UK more rigorously, and to detain them if they came from a country where there was statistical evidence of poor immigration compliance. And Mr. Justice Forbes agreed with the Tamil Information Centre that was far too broad as a sort of authorization of discrimination. And it has to be clear from the authorization exactly what is being permitted. Simon, who was instructed in that case, also tells me there was another putative authorization from the Secretary of State at that time where they sought to have permission for discrimination in this context against Tamils and Somalis. But that was withdrawn just before the case. So we don't know exactly how the wider definition of race plays out in this context. That there was an argument in that case that Tamil was not ethnic or national origin per se, but it was a race in a wider definition of that term. That argument wasn't fully ventilated. So we don't really know what that involves. There's slightly different rules for disability and religious discrimination. They're on the screen there. Religious discrimination is slightly interesting because decisions to refuse or vary leave to remain are exempt if they are made on certain grounds, namely exclusion in reasons of the public interest. So other forms of exclusion in decisions of leave to remain or enter are not exempt. So just pausing there, it's quite extraordinary the level of design that discrimination law as a whole doesn't apply to a huge swathe of immigration decision making. For example, I haven't spoken too much yet about disability, but so a refusal of leave to remain on the grounds that an individual, when here, will be in need of reasonable adjustments or in other ways support as a consequence of their disability. That is entirely exempt from the Equality Act at the design level. Just briefly, Schedule 18 also deals with the public sector equality duty and exemption into Section 1491B, which is the bit that deals with equality of opportunity between groups. But that doesn't give rise to a carve out for other parts of the PSED. For example, the need to foster relations between groups. So, for example, you could imagine an instance where leave to remain or is revoked in respect of a community leader that's been doing work between communities. You might require a decision maker there to consider the need to foster relations between groups in respect of that decision. Next slide, please. Dealing then in how this plays out with immigration decision making, I'm conscious of the time, so I'll try and rattle through this fairly quickly. Next slide, please. The story in a nutshell is that the statutory exemptions that we've just seen have meant that the impact on individual decision making, as far as I can see, is fairly minimal. But as I've mentioned, arguments under the ECHR potentially give rise to a bit more scope. We're going to do a whistle-stop tour of 3 areas without hoping to be in any way exhaustive, just to touch on a couple of areas where this could be relevant and perhaps hasn't been. So firstly, looking at visas, certain countries, as we all know, you need to have a visa. Other countries, you don't. We have visa exemption regimes. In that Tamil Information Centre case that I've just mentioned, that we've seen that the ministerial authorization for discrimination on the grounds of race needs to be specific. And then you can imagine cases, in which we'll come to, where those authorizations themselves are challengeable. Racial profiling is perhaps an underdeveloped part of ECHR case law. There's this case that I've got on the slide, FM and Russia, where in essence applicants were trafficked from Uzbekistan and Kazakhstan into Russia, and they were trafficked. They reported various horrific crimes to the police, who essentially dismissed them out of hand. And the Strasbourg court held that a discriminatory attitude towards foreign domestic workers gave rise to the police's failure to properly investigate. So we do have a bit of a concept of racial profiling in ECHR case law, and it's possible to imagine that sort of argument could be run in respect of decisions as to which countries need visas, and particular decisions on visas as well. Another sort of high-profile area of case law that's come up recently in respect of Palestinians is resettlement family reunion schemes. As I'm sure everyone will know, there was the Ukrainian resettlement scheme. There was a specific ministerial authorization in respect of that, such that Ukrainians, as a consequence of the conflict with Russia, were not required to give their biometrics in order to apply to come to the UK. There were then, in respect of Afghans, in respect of whom there wasn't a similar scheme established, there were arguments raised that differential treatment in respect between Afghans and Ukrainians was discriminatory on Article 8 and 14 grounds. So again, not using the Equality Act here, using human rights-based arguments. That argument got fairly short shrift, both in the admin court and in the Court of Appeal, where fairly broad brush points were made about different security situations, at least in the open judgments. A few of my Palestinian clients, we've been doing a bit of thinking about this, in perhaps a way of making this more of a sort of procedural argument, that a Palestinian applying for a visa has to go through a number of really difficult procedural hoops, including, well, all of the well-known issues that the Home Office put people through. And even if they ultimately have to give their biometrics, it's still incredibly burdensome, cumbersome for them to go through that process. So there may be some arguments there that could be run, but again, not under the Equality Act. And finally, very conscious of the time, these sort of arguments play out in the nationality context, in particular, where there are deport decisions based on individuals that, but for some historical accident, would have been British citizens. So, for example, there's the case of Johnson, which went up to the Supreme Court, where an individual who lost out effectively on British citizenship by birth as a result of his mother and father not being married at the time of his birth was due to be deported. And in that case, the Supreme Court held, applying Articles 8 and 14 read together, that accident of history wasn't a permissible basis on which to deny him citizenship, and therefore that amounted to a block to his deportation. So you can see in a number of these contexts where discrimination-related arguments may have success or have had success, but they are not under the auspices of the Equality Act. They're under different regimes. So that's enough from me. I'm going to hand over to Catherine.
Thanks so much, Finn. Good evening, everybody. Thanks for joining. I am going to look now at the past 15 years of the successes and the failures or the no-shows of the Equality Act in immigration detention cases. It's a kind of spin-off, I think, of This Is Your Life Equality Act. I was thinking as I was preparing for this. It assumes some familiarity of both the Equality Act framework and immigration detention, albeit situating the Equality Act as one of the constraints on the statutory power to detain for the purpose of removal, along with other constraints, as we know, vitiating public law errors, failures to adhere to the requirements of policies concerning vulnerable or disabled detainees, common law Hardiel Singh principles, or the requirements of procedural fairness and the Human Rights Act 1998. And of course, I mentioned we'll look at some successes, failures, and no-shows. In particular, we'll look at cases where there have been breaches found of the Equality Act, mainly in relation to breaches of the public sector equality duty or the duty to make reasonable adjustments. And we'll look at some of the most prominent sites for the deployment of equality grounds in detention cases. The treatment of vulnerable detainees, the seriously unwell, torture survivors, the detention regime, and segregation. As Finn said, it's not exhaustive, it's not comprehensive, it's a whistle stop. So let's begin. Next slide, please. Oh, next slide, please. Thank you. The first set of cases concern challenges to unlawful detention, which at their heart concerned the Secretary of State's policies on the treatment of vulnerable detainees, and specifically changes to those policies. And there is the case of HA Nigeria in 2012, and then we'll look in a moment at medical justice case in 2017. Two cases 5 years apart, with no real game changers or big points of principle in terms of the development of equality law in that 5 year period. And I think it in that early period and as of now, that holds true. HA, but it's worth having a look at them and thinking about how these can be, what points might be helpful in the future. HA Nigeria is a judgment of Mr. Justice Singh, as he then was, and the facts of the case or the fact pattern will be familiar to many practitioners in this area, albeit that the facts are at the serious end of things. HA was a paranoid schizophrenic with delusions, and he was detained at Brook House and later Harmondsworth. The staff noted paranoid delusions, self-neglecting, bizarre behaviour, persecutory delusions. He would not eat in the dining room. He would only eat bread and milk for fear of being poisoned, and would only sleep on the floor due to his fears. A Rule 35 report was conducted notifying the Home Office that HA had a special illness or condition, and a psychiatric team at the hospital diagnosed a psychotic illness requiring medication, including and drugs were administered by injection without his consent on 3 occasions. He was also for a period an inpatient at Hillingdon Hospital under Section 48 of the Mental Health Act 1983. Despite all of that material in the defendant's possession or in the Secretary of State's possession, and despite requests to transfer him to Immigration Removal Centre and release him, he was transferred back to the IRC without any notice, and detention was maintained on the basis that deportation was considered achievable within a reasonable time frame. Detention challenge was between 2009 and 2010. Focusing on the Equality Act issues and the context for them, Mr. Justice Singh considered the public sector equality duty under Section 71 of the Race Relations Act 1976 and Section 49A of the Disability Discrimination Act, and the definition of disability being a mental impairment which has a substantial effect on a person's ability to carry out day-to-day activities. And there was really Mr. Justice Singh had no trouble in deciding the Equality Act issue in this case. He noted at that time the public sector equality duties under the Race Relations Act and the DDA had been replaced by the Equality Act 2010, and that act entered into force on 1st of October 2010. And the reason I'm spending a bit of time on this case is because it's such a familiar fact pattern, and because the reasoning is fairly simple on this case, and helpful, I would suggest. The issue before the court was that the Secretary of State had changed her policy, her detention policy, in August 2010, which went from stating that the mentally ill were normally considered suitable for detention in only very exceptional circumstances, to treating those suffering from mental illness as being suitable for detention unless suffering serious mental illness which cannot be satisfactorily managed within detention. The defendant said, no, there's no change at all. It was a simple reformulation of the policy that existed all along. The decision making in this case, and the review and the decision to reformulate the policy was introduced without any prior notice or consultation with relevant departments, the NHS or NGOs, and there was no equality impact assessment. The claimants had argued that whether or not the policy changed didn't alter the application of the public sector equality duty. And the public sector equality duty didn't require a policy change. Mr. Justice Singh found some force in that point, but it was unnecessary to consider further because in any event, the usual practice under the public sector equality duty had not been followed, which the defendant accepted. In that there was no public equality impact assessment. And in the judgment of court, that meant, on that simple basis, that the duties, the public sector equality duty, had been breached. Next slide, please. Unfortunately, that victory was somewhat short-lived in terms of on a general level. The court was told in HA that an equality impact assessment was being carried out, and subsequent cases that I've mentioned on the slide found no, there wasn't really a policy change in 2010, accepting the Secretary of State's evidence, and actually the Equality Act, though then in force, was not raised at all. Next slide, please. The second sort of major or key case is the medical justice case, a case before Mr. Justice Ousley concerning the adults at risk in detention statutory guidance. This is a case brought by the NGO Medical Justice, 7 claimants, with an intervention by the Equality and Human Rights Commission. There are a number of challenges. The key issue before the court concerned a change to the definition of torture contained in the Adults at Risk in Immigration Detention statutory guidance issued under Section 59 of the Immigration Act 2016. And as many will remember, that this followed the Stephen Shaw review, where the purpose of the statutory guidance was to prevent detainees with indicators that they are particularly vulnerable to harm from entering immigration detention in the first place, or making sure that they are released subject to, unless there are strong countervailing reasons. And being a victim of torture is one of the indicators of vulnerability and risk. There's a public law findings in terms of the definition of torture in the statutory guidance, which is not concerned with the Equality Act at all, but Mr. Justice Ousley found that the reformulation of the definition of torture in the statutory guidance went beyond Section 59 powers, was inconsistent with other policies such as the detention centre rules and Chapter 55, and specifically on the public sector equality duty. I must say this part of the judgment is a little bit difficult to follow, but it goes something like this. 1, I didn't really see any point in mentioning the Equality Act, despite the claimants and the Equality and Human Rights Commission going on about it. But 2, I probably do have to say something about it, because I have already found, following the judgment in EO on the torture definition, that the Secretary of State didn't really understand the torture definition or the true meaning of her policies in the first place. That led Mr. Justice Ouseley to find it inevitably follows that the Secretary of State's consideration of the equality impacts and duties will have been undertaken on a false basis, which I found to be, one, quite entertaining, and two, actually, when reading through some of the cases over the past 15 years on detention, it's somewhat of a familiar theme that either the Equality Act, as I say, is a no-show, or the courts have asked, is there really any point in deciding it? And if the Equality Act point is decided, it's often because another ground has already been made out, so it inevitably follows that there will be a breach of the Equality Act too. Next slide, please. Two cases. One other case that shows that is the case of D, a judgment of Charles George QC, where the court found that D had been unlawfully detained because of the Secretary of State's failure to consider mental health issues when deciding to detain and maintaining the decision to detain, due regard not being given to disability. And again, on the facts, there'd been a breach of the public sector equality duty for the same reasons as the court found there'd been a breach of the failure to consider disability or indicators of risk under Chapter 55.10. And another case which sort of piggybacked or followed D is a case of AMG. Again, maybe because it's late in the day, I'm finding this also quite entertaining, but it shows the limits of the arguments or the creativity of lawyers in the early days, and as ever in the claimant sector, and the limits put down by the court. So in AMG, Mr. Justice William Davis said AMG's arguments go rather further than the arguments in D, namely that the Secretary of State took account of the risks of absconding and reoffending when making her decisions, which clearly she did, but she did not have regard to the fact that these risks were or might have been caused by his mental illness. And by doing that, she treated AMG in the same way as somebody who deliberately decided to abscond. In doing so, the Secretary of State did not have due regard to the need to minimise the disadvantage suffered by AMG, which was connected to his mental illness, and that was rejected in a single paragraph, paragraph 68. Next slide, please. Just going to rattle through the next couple of slides, given the time, which and the following cases deal with detention regimes, conditions, and segregation, and we'll try to draw out one or two helpful points whilst mentioning these. Two cases on the duty on Section 19 of the Equality Act. So the first is Hussain, judgment of Mr. Justice Holman concerning the lock-in regime at Brook House. So no compliance with the public sector equality duty, but also discriminatory contrary to Section 19 of the Act because of the conditions in which Muslim detainees were placed. So being required to adhere to mandatory prayer times in their rooms, other detainees' presence, and close to an unclosed lavatory. That breached Section 19, but also Articles 9 and 14 of the ECHR. And in another case, Sultani, challenge on similar grounds, lost on the facts because the conditions were not, the conditions were deemed to be suboptimal. And in that case, it was only an ECHR challenge, and permission had been refused on public sector equality duty and not renewed. Next slide, please. Finally, and to leave you, I hope, on a positive note. So moving now to 2018 and 2019, in VC and ASK and MDA, a number of grounds are raised. The Equality Act was also raised, and in the Court of Appeal, the Equality Act ground was upheld. With a finding that the failure by the Secretary of State to make reasonable adjustments to assist detainees with a mental illness who lack capacity to participate in decision-making concerning detention, including segregation, was unlawful in breach of sections 20 and 29 of the Equality Act 2010. This is a really leading judgment, I would suggest, on the Equality Act. Probably the high point, or the best of a best example from the selection I've produced. And the case which followed it, ASK and MDA, what also won on the Equality Act because the Secretary of State conceded a breach of the duty to make adjustments in the light of VC, and VC was followed by the Court of Appeal. So happy days in both of those cases, and as I say, a high point for the Equality Act, albeit it's 6 years ago. So I'm afraid I don't have any really profound takeaways from this little run through of the detention cases. No real big points of principle. An obvious point is, as always in public law, context is king. The second point I think to take away is, what is the point? What can be gained in bringing the Equality Act issue? Depends if it's a systemic case where there might be, where the Equality Act failure to carry out an impact assessment might affect a lot of cases, but it might, in terms of, it might also assist on the particular facts in adding to aggravated damages. I suppose the only the strategic consideration in all cases would be in cases like Sultani, for example, where there are grounds, or cases where there are grounds that succeed, but the Equality Act argument fails. Then, as practitioners, we need to be aware, where we're claiming damages, where the client's claiming damages, that there could be a risk of the Secretary of State requiring a set off from any damages that you ultimately receive, a set off of costs. Now, over to Simon. Thanks very much. Sorry to keep you waiting.
Thanks, Catherine. I thought that was great. And I think there are some themes there that apply in the asylum support field. So I think, as we'll see, the cases that I'm going to talk about, 4 cases really in the last 5 years, because I think that in the asylum support field, there was a slow start in terms of reliance on the Equality Act. And partly that might have been because things have got systematically worse. And I think it's right to say that in the last 4 years, we saw a move away from self-catering long-term accommodation for asylum support to hotels initially, and then to army camps and boats, and that the conditions to which asylum supported people were subjected were worse. And I think that's part of the context for why there's been more litigation recently. But I think we can see from these cases, and certainly in my practice area, that I think that discrimination, Equality Act points are still often overlooked, or at least not deliberately considered. There may be, as Catherine says, good reasons why one doesn't want to overburden the case, especially if one is claiming damages. But I think we can also see from these cases, like in the detention examples that Catherine gave, that Equality Act is often, when it is deployed, it's deployed with great invention by the lawyers involved. I think the second point is that these cases are intensely fact-heavy. So even when we see systemic challenges being made, very often we see the courts looking at a lot of factual material about the impact on the people affected, defences by the Secretary of State about what they did or didn't do. And they are, I think, it's fair to say in the current iteration of Equality Act claims, at least in asylum support, they're rarely about some crisp, nice point of law. They're always based on a lot of, or almost always based on a lot of evidence. Despite that, and the existence of, say, the county court for damages claims, where one might think that fact-heavy claims would go, perhaps in some circumstances rising to the Court of Appeal, at least in reported cases and publicly available cases, judicial review still dominates as the venue. And actually, in those judicial review cases where Equality Act points are raised, they are, I think, almost never raised as the only points. There are always common law public policy points being raised, interpretation of guidance, reasonable conduct, when to be unreasonableness being raised as well. It may be that there are county court, well, I'm sure there are county court claims that are being brought, but one might expect that they will often settle. I've certainly been involved in some that have been brought but settled, and that may be why we don't see them percolating up into the reported area. The kind of points that are taken are often both, there are systemic points, often PSED points, but also there are often claims being taken that this particular individual should have been given a reasonable adjustment or was discriminated against by the scheme that operated. And in this field of asylum support, I think differently from detention, the Equality Act will provide a basis for damages, which is, first of all, available when no common law basis for damages is available, and also likely to be more generously assessed under the Vento bans than would be at least a respondent's approach to assessment under Article 8 or Article 8 and 14 of the ECHR. So I think when it comes to individuals who can show that they have lost out on accommodation and are claiming damages as a result, then Equality Act points are very valuable. Certainly that's where I've used them mostly in my practice. So I want to take you through 4 different cases to illustrate those points. They're all judicial reviews. And while we don't, can I have the next slide, please, Ray? And while I haven't, I'm afraid, since I'm afraid in somewhat of a rush when finally completing these slides, I haven't included the neutral citations, but I will do so in any version that goes out to people who are watching this. And you're welcome to email me and ask me for them. So the first of these judgments that I want to take you to is the really important case of DMA. So DMA concerned a number of claimants who had, where there was a long delay in arranging accommodation under Section 4 of the Immigration Act 1999. That's the accommodation power for failed asylum seekers. That's people who've already had an asylum claim and are making representations for a fresh asylum claim. And in particular, one of the claimants, Mr. AA, was very ill. He had end-stage chronic kidney disease. That means he couldn't walk up the stairs. It means he needed a special diet, which didn't seem to be capable of being provided in the hotel accommodation where it was full board. And he needed to be located in a place and have transport arrangements to and from the hospital that was providing him with dialysis. It took the Secretary of State 9 months to arrange that. He did provide Mr. AA with some accommodation, but it was so poor that Mr. AA left it and ended up then becoming street homeless for a while. The judge, first of all, held that that was a breach of Section 4 as unlawfully long. So this is an example of a case where the Equality Act points are in no way standing on their own. But there were some important arguments being made under the Equality Act, which may or may not have particularly benefited Mr. AA, but certainly serve as pushes to the Home Office to change their practice. So as I mentioned on the slide, the judge concluded that the systemic delays put severely disabled people at an unfair disadvantage because they were even less able to cope with having no or no adequate Section 4 accommodation than people who don't have disabilities. The Home Office said that there wasn't any accommodation available for someone like Mr. AA in London. And interestingly, because we've sometimes worried about what one's response might be to a bold assertion that we just couldn't find any, the judge said, I just don't believe you. I don't believe you couldn't find accommodation, ground floor, single man, London, big city, lots of places. Just rejected it. Interestingly, for the purposes of asylum support, where it's under the asylum support contracts arrangements, which ought to be, in practice, all of the accommodation that isn't army camps and boats. The judge received evidence that the Home Office had made these contracts on the basis that they would pay a fixed amount for each person accommodated, whether or not they needed special accommodation, whether or not they had disabilities, for example, that would require the accommodation to be adapted, would require it to have special facilities or be in a particular place. And so what that great arrangement that Home Office officials had entered into in these £1 billion 10-year contracts with Serco and so on, was that it meant that they couldn't say, well, look, it's more expensive for us to arrange accommodation for disabled people, because under the contracts it wasn't. So it might have been harder for their agents to find the accommodation, but the agent, the Serco and so on, couldn't pass on the additional costs of that accommodation to the Home Office. So he said that wasn't a defence or a justification for the discrimination against Mr. AA. He didn't only find that it placed him at an unfair disadvantage, but he concluded, therefore, that there was discrimination on disability grounds against Mr. AA, and that there had been a failure to make adjustments in the practice of providing Section 4 accommodation. He also then went on to find, and this is a theme that we see in several of the other cases, that the Secretary of State, by failing to gather in any information properly about how long it took to organise the accommodation, how long disabled people might be waiting for accommodation, that there was a breach of the public sector equality requirements. So in essence, he said, you can't be making a proper assessment about whether your scheme, about the impacts your scheme is having on disabled people, if you don't have any information about the impacts it's having on disabled people, which may seem an obvious point, but it's really helpful, I think, to have it spelled out. Next slide, please. So the second case is DXK, and that was only given last year by Paul Bowen, King's Counsel, sitting as a Deputy High Court Judge. And this concerns, in many ways, similar themes to DMA case, but for pregnant women. It's brought by an individual pregnant woman who was in inadequate Section 4 accommodation, a hotel, and it took 109 days to get her into self-catering accommodation. Unlike the judge in DMA, he said, I'm not going to look at the systemic failures here. They're academic. For the claimant, I'm not going to look at whether the delays in arranging accommodation are unlawful. And one of the reasons, key reasons he gave for not looking at it, was that the Home Office said that they changed their practice and their policy. So he said, well, I'm not going to do a historical look at whether it was unlawful. There's a new regime, and I haven't got any evidence about how that regime operates. But what he did do was decide the public sector equality duty argument that since the Home Office weren't gathering any data about how long it was taking to provide accommodation to pregnant women, that therefore they weren't complying with their public sector equality duty in respect of women. So he accepted that argument. And I think there was no real evidence that they'd started doing it. So he obviously felt the need to do it. Next slide, please. Third case I want to mention is a decision of Mr. Justice Fordham, only given earlier this year, one of a pair of two decisions that concern both Leeds City Council and the Home Office about having access to or being provided with accommodation under the Schedule 10 of the Immigration Act 2016, which is accommodation that's provided to people who aren't asylum seekers or failed asylum seekers, but are people who are usually pending deportation and therefore on bail and shouldn't be detained, but can't accommodate themselves, don't have the resources to. And he did consider the systemic problem points, even though they're academic for the claimant. He thought that he had the material needed to decide them. It, like a lot of Michael Fordham's judgments, it reads like a mini extract from Fordham on judicial review. So it's got wonderful headings and pithy summaries of all the case law. So it's a great case to go to if you're preparing a seminar on Equality Act developments in Simon's Port, as I was, he held that the fact that the Home Office had now not even made an equality impact assessment for bail accommodation and hadn't gathered any data about its impact on people meant that there was a breach of the PSED. And again, a similar theme to the one that Catherine mentioned. In fact, by that stage, after 5 days of in court, the Secretary of State had even accepted it. Interestingly, from the point of view of those of us who say, well, it's all very well to get these judgments, but what happens when 2 years later they still haven't done it and you have to go back to court for a new client? He wouldn't set a time limit for the Secretary of State there and then, but he did give liberty to the claimant to come back to him and say, look, they still haven't done it, set a time limit. So I think that's a really interesting example of remedies from the judge. He's always an interesting judge on remedies for other things. And he said that there had also been a failure to make reasonable adjustments. Again, the Secretary of State hadn't gathered any information. And there was a failure in this specific case of BRZ because the BRZ's disabilities meant that he needed no step accommodation, but the Secretary of State had put him in stepped accommodation. Lastly, next slide, please. TG and others concern, even more recent, only judgment from March, concerns asylum seekers being accommodated at the Wethersfield camp. The judge held that there was no breach of the Section 95 duty to provide adequate accommodation or of the human rights of the claimants under Article 3 and 8, that the quality of accommodation in the camp was good enough by then. But he did hold there was a breach of the PSED because he said that when the Home Office had changed their policy and decided they were going to accommodate people with disabilities in Wethersfield, they hadn't made any assessment of the impact of that on people with disabilities. But he found that there was no breach of the duty to make reasonable adjustments. The way the Secretary of State was operating the scheme, or the scheme they had, was enough. Secretary of State, if they thought a disabled person could be accommodated in Wethersfield, they would accommodate them. If they thought they couldn't be, then the reasonable adjustment they made was to put them in some other accommodation. And the judge thought that held that met the requirements. And this was a rare example, I think, of a breach of the PSED on the basis of race, because there was evidence of racial abuse at Wethersfield, but the judge held that the Secretary of State had shown that she was dealing with it well enough. However, TG was an example of the Secretary of State's policy not actually working, because the judge held that TG's medical condition meant he should have been moved, and the fact that he wasn't was a breach of the Equality Act in his particular case. I think that's all I have, Finn.
Lovely. Thank you very much, Simon and Catherine. I'm maybe missing them, but I don't think we've got any questions in the Q&A just yet. Please do feel free to ping them in or put them in the chat, whatever is easiest, and we can answer them. Just while we're waiting, if there is anything interesting, that I think probably the most hopeful cases in both yours and Catherine's presentations were reasonable adjustments related or disability related in relation to the PSED, which was an interesting aspect, particularly in light of, albeit in a very different context, what I was talking about at the outset in relation to individual and immigration decisions having entire carve-outs for disability discrimination. It doesn't strike me as obvious why you'd have a system that permits at the design level discrimination on the grounds of disability in immigration decisions, or why that's a legitimate form, bearing in mind that you could have a much more granular sort of approach where different parts of disability discrimination apply rather than a complete carve out all the parts that that require some form of justification or something applying.
Well, yes, I mean, I certainly had thought that one of the explanations why we don't seem to see those kinds of challenges to individual decision making is that often where the stakes are very high, there's a right of appeal from the decision, or there's judicial review of the quality of the decision making, and so the fairness of the procedure you get in immigration decisions isn't so material as it is, for example, in detention, where you're basing your challenge on the process, because you're saying, well, it was unlawful detention back then, can't go back and legalise it. But in an immigration decision-making context, if you've got a right to appeal or judicial review, if you get the visa in the end, the fact that along the way you didn't get reasonable adjustments at the interview may be a hard point to raise. You've got other remedies. I don't know if that's part of the picture.
That may well be right.
But also, I do wonder if there's an article, I don't know, I haven't thought about it properly, there's an Article 14 challenge out there to these exceptions to the Equality Act, at least in the sphere of Article 8, as to why I shouldn't be able to invoke the Equality Act to challenge these matters when you've given it in other areas, in other fields on a similar basis, or whether the courts would say, well, you don't need the Equality Act, do you? You've got Article 14 of the ECHR. So if your decision-making is racist, then you can bring a challenge under Article 14, with Article 8. You don't need to be able to rely on, or if the immigration officer didn't make any disability adjustment for you, you've got rights under Article 14. But yes, I think that I do worry a bit that when the Disability Discrimination Act and the Race Relations Act were being drafted, that the Home Office did a very effective job of lobbying to get these exceptions put into those acts by, as it happens, Labour ministers who were proposing those bills.
I've just seen that we have a question from Tublu, our colleague. How about differential impact on nationalities, such as a Windrush type visitor visas for certain nationalities? Well, I suppose that comes into my ambit. I mean, I think that is the type of point that I discussed very briefly. I haven't seen any cases where a sort of grouping of people or a grouping of nations requiring a particular kind of visa has been challenged on equality grounds. It's certainly possible, I think, to imagine that.
I think it's very messy though, because I think first of all you've got the carve out for decisions based on nationality. You've then, once you get to race, got the carve out for decisions based on national origin or ethnic origin. And I also think you've just got a wide. So I mean, I was reading recently the reports on the Labour government's 1968 immigration bill, which was adopted in a rush to stop East African Asians from coming to the UK when they were being subjected to racism by the newly independent governments in East Africa. And the government was advised, well, it's probably going to put us in breach of our obligations under Article 14 of the ECHR, because we're basically doing it because they're brown. We're basically doing it because they're a different race. But I think trying to have that narrative today, even if you singled out the West Indian nations, for example, the Caribbean nations, the idea that you would be able to present that as a colour bar because those nations are overwhelmingly black, I just think, I wonder how receptive the courts would be when there's a whole narrative that we don't have countries. And I see that argument that we don't have countries that are a particular colour or race anymore. Points that would have been much more easily understood in 1968 as being racist, which I think is racist. I think the other problem is that what people don't bring into the room, or that they do bring into the room, is that immigration control, certainly many of us see it, and I think many people who don't have a problem with it see it as inherently racist. So the idea that you could challenge it as racist is inherently weird. I mean, it is racist, right? You'd say it was racist. Your opponents would say it's racist. You think that's bad. They think it's good. But we all agree it's racist. So you can't be unlawful to be racist. I think that's the subtext, I'm afraid, to a lot of those discussions.
Brilliant. Thanks. Oh, there's some in the chat. Bear with us. Firstly, there might be Firstly, we've got this question from Diane. I don't know which order to take them. Sorry, I'm trying to read these quickly. Perhaps Shushin's.
There are differences, but it's complicated.
Yes. So firstly, sorry, I'm
I think Diana asks, is there differences between the well, people can see hopefully in the chat what Shu said, the point Shu Xin makes, which is a really good one.
I think it might be to host some panelists, so it might be that. I'm not sure.
Okay. Is there a way, Catherine, that we can copy Shu Xin's wisdom into some wider publication? Or Ray, can anyone else do that for us? Because
I wonder.
I'm feeling technologically we could read it out.
To Diana, I don't know if this helps. I've just cut and pasted a link to the Equality and Human Rights Commission technical guidance on the PSED. There's other guidance, of course, but if the question's about I'm not sure it really answers the questions, but the whole annex there and some guidance around the different exemptions, just given the time. Shu Xin's response. Let me try and cut that. Yeah. So from Shu Xin, I've just added it from me. Is that what you're looking for?
Can everybody see it now, Catherine? That would be that's my question for you, Catherine. Can everybody see it?
I think you're right.
We're being defeated by technology. Anyway, what Shu Xin says is there's been a get around to the carve out that you use instead of the Equality Act, irrationality and the common law principle of equal treatment. So that you step back to the common law instead of using the statutory scheme. I hope I'm doing justice to it here, Shu Xin. And she's referring to the challenge brought by asylum aid to the rule changes to family reunions for stateless persons, and the Ramphel case, which was about failure to provide immigration documents for people with Section 3C leave. So yes, I mean, I think that's really important to note that certainly shouldn't it doesn't mean one has to give up. What I think it does in the context of this talk we've been having is show us that the Equality Act mustn't be seen as a complete code by any means for dealing with inequality in the field of immigration. That if you're looking at an inequality, a discrimination-based challenge in immigration, you're probably going to want to be certainly making sure you've checked the options of the Equality Act, the common law principle of equality, rationality, as Shu Xin points out, and the ECHR. I haven't missed any other
parts of the arsenal
principles. Yes. And of course there isn't any, and that may not be more work. I mean, coming back to Catherine's point about running up costs, it may well be that you say this is discriminatory and it breaches all these different schemes. And, you know, at this stage, we don't mind which one the court looks at. But of course, sometimes there will be differences, and one of those differences may be damages.
I think that is everything in terms of the questions. So it just remains to thank everyone for coming on this lovely sunny day. Thank you for joining us, and thank you to the questioners, and thank you to Simon and Catherine. I don't think we've provided our email addresses. They're our initials followed by our surnames, our initial full stop followed by our surnames at dowdystreet.co.uk. In case anyone wants to follow up with any of that. Other than that, I think that's everything.
And I think we can send out the notes. Is that right, Ray? I think that's right. We send out the notes, which will have the mutual citations.
Thanks very much.
Yes. Bye-bye.
Bye.
Thanks, Ben.